Parliament still has a function. Parliament can certainly control that by imposing limitation.
It has done it. Is my point.
Of course, that's your formulation.
Yes.
That Parliament has by providing for royalty in section.
Now, why did I'm so sorry.
But assuming that suppose the alternate formulation which was accepted in the subsequent judgment is held to be correct, that will never stop Parliament from.
The alternate formulation will.
For instance, Parliament can still make a bifurcation between the nature of the minerals which are of crucial importance in national security. Parliament can impose different sets of limitations.
But I'm sorry, that will again not then fit in entry 50 because it must be by law relating to mineral development, not a law relating to the taxing power of the state. The limitation must flow naturally from a law relating to mineral development.
But that goes against you, Mr. Salve, because if you see the alternate formulation which you say that Parliament has not made, the alternate formulation is taxes on mineral rights subject to limitations imposed by law by Parliament. If this was the formulation, then the domain of Parliament would have been much larger because all that they had to do is to impose a limitation by law. The limitation, the power of Parliament is much narrower because it has to be by law and it is a law in the interest of mineral development.
I'm sorry, my lord. The point is slightly different. I see what my lord is saying. And in either way, Parliament can say a high tax is counterintuitive to mineral development and limited. So either way, Parliament could have done it. The point is slightly different.
Mr. Salve, you gave example of uranium. Now, suppose government of India comes out with a law, Union legislature, putting constraints on imposing tax on uranium. That will be also a step towards mineral development.
I'm deeply obliged. I'm deeply obliged, my lord. In fact, my submission is going to be, that is why when entry 50 was crafted in 35 and continues, what they had in mind was, and that's clear from the language of the entry, I'm not going on any external material, that when Parliament makes a law relating to mineral development, the architecture of that law may itself impose limitations on what tax you can have on mineral rights. That is why the limitation flows from a description. The description is limitations imposed by a law relating to mineral development. So the test is, if by the kind of law which Parliament has made, a tax on mineral rights becomes incompatible with mineral development as contemplated by law relating to mineral development, that right gets limited. It's not as narrow as saying don't.
But then you have to demonstrate that a tax on mineral rights is incompatible.
I'm deeply obliged.
If you
That's the exercise.
Establishing that a tax on mineral rights is incompatible with the very premise of this law,
yes,
namely the MMDR Act, then
yes,
of course that is outside their domain.
That's my submission. That's what I have to develop. Your Lordship had one yesterday on more.
But that submission can't be an a priori submission based on the entries.
No,
it has to be specifically with reference to the provisions of the central statute. That's right. That this central statute clearly evinces an intent to exclude all taxes on mineral rights by...
I will not, with respect, completely accept what my lord is saying, respectfully.
Yes, we also accept that a limitation, we should not read in a very restrictive sense.
That's all that I was...
A limitation can also go to the extent of abrogation. Possibly. I mean, we are not... I'm just for the sake of a hypothesis. But because we have the same thing in the context of Article 19.2 to 19.6. Can a reasonable restriction go all the way to a prohibition? Our court has said in a given case, a reasonable restriction may go all the way to a prohibition. So assuming that a limitation can amount to a prohibition, that limitation must appear clearly from a law which Parliament has enacted, not just that this is contrary to the structure of the law or something like that.
No, I'm sorry, Madam.
Or the architecture of the law.
Yes. Why I am saying that what your lordships have to see, it's not obviously a priori. With respect, my lord, the Chief Justice is right. First of all, there must be a law relating to mineral development made by Parliament. If Parliament tomorrow, my lord, says, I don't need to do it, I leave it to the states in entry 23 to make the laws. And end of the matter.
So this is a law relating to mineral development. That's what the law says it is actually.
Yes. Not just that, my lord. Parliament can only make a law relating to regulation and development. I'm not now on the semantics of development and regulation. I'm assuming development includes regulation. But how do you have orderly development unless you have regulation? Parliament under entry 54 and under entry 54 alone can make a law relating to mineral development. It may or it may not. If it doesn't, it leaves the field open to the states. So there is no a priori here. If Parliament takes that step of, first of all, exercising its legislative power, 246 read with entry 54 of list 1, to make a law of mineral development. The words law of mineral development, therefore, is descriptive of the law, as its very language suggests. A law relating to mineral development. It's a label. And this squares entirely with the language of entry 54. Regulation and development of minerals, mines and minerals. That's the first important element in the interpretation of this entry.
The parliamentary enactment, Mr. Salve, is the MMRD Act. It levies royalty on mineral development. Are you saying that it is tax wearing the hat of royalty that is being levied by the central government?
But that's my third proposition.
You have that proposition?
Yes, I'll tell Manoj why. Let me tell Manoj what I'm going to develop. Because
But Mr. Salve, that you already argued before us that royalty is not a tax. You said that royalty is not a tax. That's not your case.
that's why I'm saying answering this question, there is a full dress answer to this. Where do I get? May I just state my points and then develop each one of them?
Yes.
Because I'm sure a lot of them, each of them will have a lot of
areas. You may also keep this aspect in mind, that the limitation is on the taxing power of the state.
Of course.
So therefore, what is the limitation that this Parliament can impose on the taxing power of the state? It is not any kind of limitation. Of course, it should be in the context of mineral development, but the limitation is on the taxing power, which is already there in entry 50 list 2. That context we cannot also leave aside.
Yes, I'm going to be fully developing that.